Mr. Stuart, welcome this afternoon. You were here from the beginning. You heard it all, so I don't need to repeat to you the rules of engagement for you. And you have your laptop. You're free, of course, whatever you have, in writing, even though it's an oral submission, you're free to present it to the committee. In fact, I would advise you to present it to the committee. I know whether you should submit a written presentation in addition to oral with the subject of debate and some concern. And you did say that you would be willing to submit whatever you say in writing. So I invite you to if you wish, okay? So 10 minutes, sir.
Before I start, it's my time. I just wanted to say good evening to you, Mr. Chair. Good evening to the entire committee, the leader of the opposition, and to the members of both houses. Good afternoon to all Barbadians and those, to those persons who are watching. My name is Kemar Stuart. I was invited as an individual, so I am here to represent myself as in an individual capacity. However, I will state for the record, in my professional capacity, that I am a research fellow, a non-resident research fellow at the Caribbean Progress Studies Institute. However, the views this evening are mine and not that of the Institute. First observation, and I'm quoting from the bill, specifically Part 3, which deals with investigation and enforcement. I'm going to reference some words that are in the legislation: insult, embarrassment, humiliation, and I'm going to say that it is my perception that those words are very emotive, and with all good intention, you can post something on social media, well-intentioned, but cause the same effect as though you did it unintentionally with the aim of being reckless. So then who's to determine if you're punishable by the court of law? Second, is my concern that this bill empowers the police force of this country with extraordinary powers. And I say that because when you speak about search and seizure, or the section that deals with search and seizure specifically, it says here, and again, I'm reading from the legislation, nothing that I would have prepared or anything. It says, where a judge or a magistrate is satisfied on information on oath given by a police officer, there are reasonable grounds for suspecting that an offense has been, is being, or about to be committed in any place, and that there's evidence that such an offense is being again, or is about to be committed. My criticism there would be, how would the police know that a crime is about to be committed unless the police were indeed actively monitoring the citizens of Barbados? My next question would be, if indeed the police are the ones to oversee or has the authority to execute the offenses in the bill, what resources do we have in terms of a cybercrime unit to be able to man the offenses in the bill? I heard earlier by a presenter that the bill is likely to cause a ripple effect in terms of the numerous amount of persons that could be potentially held liable. So do we have the resources within the police force in terms of staff, qualifications, and otherwise that would equip them to be able to carry out the requirements of the bill? My next observation here would be, why only the police force and not the Barbados Defense Force? Outside of that, you have, in other larger countries, they have security agencies or private security agencies. In this specific legislation, it speaks to an appointed person And this appointed person could be, what was the word I'm looking for? Empowered or imbued by the commissioner of police. So either the police himself or somebody who has knowledge of a computer system or other ways that they could instruct to assist. So, prime example, we had a situation in Barbados where we had a former commissioner of police of Barbados who has specific skills. And it was public knowledge, right? It was public knowledge that a former commissioner of police of Barbados was indeed sent on retirement based off recommendations from the Police Service Commission, right? Now, I will not enter into the record the specifics of the charge. However, it relates back to my original question of actively monitoring Barbadians and internet traffic. And that includes all types of traffic, phone logs, pictures. In the bill specifically, it empowers the police to engage persons who have the necessary equipment to do decryption. So on WhatsApp, one of the most important or attractive features of WhatsApp is security, that you're not able to decrypt my messages, and that's one of the benefits of having WhatsApp. Now, if a country is attempting to bypass a big tech firm, because WhatsApp is no small firm, you are attempting to bypass the security features of a large tech firm that's not based in Barbados. You're looking for legal trouble, right? So we speak about that, and it's going international because the next part of my presentation deals with the Mutual Assistance Bill. Now, that bill originated from the 1980 Mutual Assistance Act to deal with criminal matters. And the amendments being discussed here today, they deals with mutual assistance as it relates to computer-related crimes, right? Before, the application of that bill spoke specifically to Commonwealth countries, countries that were signed on to the United Nations War on Drugs and Crime. And as of late, the new amendment says with any other country that has signed on to the Budapest Convention. Right? So what is so special about these additional countries that will be added to the list, where information sharing will be occurring between government to government? And in the bill, there are clauses which speaks to confidentiality of requests between the two countries. Right? Now, the esteemed gentleman on my right and immediate on my left, they're all politically affiliated persons. And in the bill, the mutual, it speaks specifically to crimes of a political nature, and it excludes, and it lists the crimes that will not be considered to be a political crime. So why not create a section in the Cybercrime bill which speaks specifically about criticisms of public officials and what is allowed from what is not allowed, to give the public a sense of confidence that public actors and public officials are not abusing state power to shield themselves from criticism. And they say that in the context that we have a 29-1 in the House. Before it was 30-11 twice. So how are we as a public to perceive a state having a lopsided and imbalance, a serious imbalance of power, and then you're attempting to criminalize free speech in a way where the public, the voting estate now, which is not elected, you want to regulate their speech. But parliamentarians have covered in parliamentary privilege, meaning that any of the gentlemen on my left or on my right could get on the floor of Parliament and criticize, insult, embarrass, do whatever. I have parliamentary coverage, but I don't. And the one area that I have a freedom of expression, which is social media, then you attempt to regulate it and over-regulate it to the point that you have actually gone past the security measures that the big tech firms, the same persons who made the apps that we use, you want to over-regulate it more than them, right? So those are my general concerns there. I want to come to the end of my presentation soon because I don't want to go extensively. But the last part deals with the ability of, this is 25 now, section 25, because I think I deal with the encryption information and allowing persons who would decrypt data. But then it says record of seized data to be provided to owner. It says where a computer system or computer data has been removed or rendered inaccessible to the owner, and the police under the bill has the power to render your devices that they confiscate inaccessible to you, right? It is saying here that the person who has control of the system following a search or seizure under section 23, the person who made the search shall, and at the time of the search as soon as practicable after the search, make a list of what has been seized or rendered inaccessible with the date and time of seizure, and give a copy of that list to the owner of that data. But then in the next breath, it says that the police, under subsection 3, a police officer or an approved person may refuse to, again, approved person may refuse to give access to or provide copies of that computer data referred to in subsection 2 if he has reasonable grounds for believing that giving access or providing the copies would be prejudice the situation, the investigation, it would prejudice the investigation in connection with what the search and the seizure was about, and 2, another investigation connected to the original investigation in respect of the search and seizure, which means that if you take away my devices in a search and seizure, and I'm cleared, if a police decides to get overly emotional and petty, he could say that he's keeping my devices and this law allows him to do it without recourse or without stipulation, saying to the police how long you could keep my devices for, the same way you would treat a person or individual who comes into contact with the law. There's a set time that you can keep an individual in a police station without formally charging the person or committing them to be answerable to the magistrate court or whatever court there is. So it should be, the same should be with this. It says here that if they believe any other criminal proceedings,
Mr. Stuart,
yes, please.
one more minute.
Yes, it says here that if they believe any other criminal proceedings or that may be brought in relation to any investigation. So my question is, if you believe that the first charge was not, you were not successful, and you go back to the drawing board and you believe you want to build another case against me, you continue to keep my devices and pass laws to preserve my data that I can't even swipe or clean my own property that I bought with my own money that had nothing to do with the state, but it was a private purchase, and the state of a country should not be depriving the citizens of the private property in that other phone. And if the government wants to engage apps and traffic data and web data, the best thing to do would be to engage the big tech firms like WhatsApp, Facebook, Telegram, whatever, as opposed to us overreach as it relates to empowering the police with extraordinary powers for a job that we don't know if they have the requisite knowledge, skills, or experience to handle. Thank you very much.
Thank you, Mr. Stuart, and we now invite committee members to, if they wish to engage you. Okay, if none yet, Mr. Stuart, I made some notes. Section 19.3, and you know, you had concerns about that section, saying that, well, effectively, and correct me if I have misinterpreted you, that, you know, you should be allowed to ridicule a person, embarrass them on social media, and you might do that, you know, with intention or without intention, either way, and find yourself subject to the criminal law. That's, am I interpreting you correctly?
No, you are not.
No, so explain, clarify what you said there on those issues.
And you're
When
well,
you spoke about ridicule and embarrassment,
and a well-intentioned post without malice, you can cause humiliation, embarrassment, or any of the other emotional words that were used with a well-intentioned post that may be true, right? But it causes the same effect as though you did it with reckless intention. So who's to say, or who can speak to my intent for posting it? When I tell you it was good, but you trying to suggest that it was bad, or they told you it was good. So then I have to come to court to prove that my intention indeed was not sinister, but more positive. That's my interjection.
all right? But have you read section 19.5? Have you fully read the section, sir? Because 3 says whether you've made this post to cause which causes embarrassment or ridicule. But you don't care whether it's true or false. But section 19.5 gives you defenses. No, I mean, you may. So in other words, if it is true, you can prove it is true, you get off. But suppose someone, because they don't like Mr. Kemar Stuart for whatever reason, or Mr. Edmund Hinkson, because I'm not personalizing it, and because of that, to get at you or Edmund Hinkson, they say something bad about your mother or my mother, they're prostitutes. To get at us, you or me. They can't prove that that is true. And to use your words, well, the intention, I mean, they couldn't care less about the intention, whether it's true or false. Are you saying that Kemar Stuart, his mother, Edmund Hinkson, his mother, should have no redress, should not go and make a complaint to the police, but this person X, for whatever reason, political, otherwise, has said that my mother, or in mother's case, I am a prostitute. It is not true. Are you saying they should have no redress? The police should say, man, too bad. A person could say anything they want about you. Maybe just because, what did you say? Because they're a public figure. Because I'm a member of parliament, because you are a public figure of sorts, a former general secretary of the Democratic Labour Party. Person should be free to say anything about you or your mother. And there's absolutely no truth in it, just to embarrass you or ridicule you. Are you saying that that is how the laws of Barbados should operate, sir? And would you be happy in that situation that you, your mother, or in my case, Edmund Hinkson, my mother, has no legal redress whatsoever? And person should be free merrily to go along to say that about your mother, my mother. And obviously, we know the situation is forwarded many times. The whole goes out to the whole world repeating it, repeating this falsehood, time and time again, just to embarrass you because you are a public figure of some sorts, or me because I'm a member of parliament.
Uh, your interpretation and your examples, I mean, it will invoke some emotion, a lot of emotion, because you're speaking about a female. That's my queen, my mother, you know? And then assuming your mother will be your queen, right? So it will invoke an emotional response at first. However, there's not an emotional place. I started by saying that those words of humiliation, embarrassment, were emotional words, right? Secondly, laws of this country under the Defamation Act provides coverage already as it relates to those examples you just gave. So it wouldn't fly, right? So there's no need to overly regulate, because let's be honest, that comment can nowhere be taken in kind spirit at all, whatsoever. Any comment, right, like that. So as a police officer, right, a police officer fresh out of school, still very young, masculine, aggressive, very interested in proving to his superiors that he can make it up the ranks, you know? He has to sit and determine for himself if this statement that he's looking at, if it merits him making an approach to go convince the magistrate to get a warrant to come and charge you, right? And this police officer is looking at this statement about my mother. He has to consult with his superiors before he does anything. He my question there would be, right, because not to drift too far from the point, my answer to you would have been, no, I would not let something like that to happen. However, if a parliamentarian is afforded free speech with parliamentary privilege and coverage, I'm saying that the public should be afforded that same right within measure. However, if you want to regulate the public, you have to regulate yourself. And this is where I agree with Mr. Green from Starcom, that a Freedom of Information Act should be on the table as opposed to a bill to...
But Mr. Stuart, we're not talking about freedom of information legislation.
Yeah, but you got to give to get
I need to be clear, sir. I need to be clear. Do you accept that Section 19.5 provides a defense? That if what you say is true, it is public, in public interest to say so, you have a defense. Whether you already have defamation legislation which provides a defense or not, do you accept that those defenses, truth, comment, triviality, privilege, absolute qualified privilege, provide a defense to what somebody says about you, or the examples I gave, your mother, my mother, even if they embarrass you, your mother, my mother, myself, do you accept that there is a defense and that somebody who says that is covered?
I do not, I am not sure the way you crafted it. Because going back to the example of the police officer, that young, masculine, aggressive police officer has to determine, hold on, has to determine, first things and foremost, if an offense has been committed, right? Based off the legislation, if an offense has been committed, and if indeed that the matter is trivial, as you said, the matter is truth, as you said, and it speaks here provided under the Defamation Act. If the Defamation Act covers your question, right, then the Defamation Act stays, and the Defamation Act will be my point of reference as well. However, when you go much further than that, outside of the scope of what's provided, right, and it's true, if I speak the truth, I should not be charged, I should not be prosecuted, I should not be harassed in any way, as long as what I am saying is factual and truth, and I can back up my statements with written or video evidence.
Yes, and where in this section that you have quoted does it say otherwise? Since the defamation defenses apply to this section, where in this section that you have spoken about, is it contradicting what you just said?
If it contradicts what you just said?
Yeah.
Yes, the
Where
legislation is very contradictory.
where
Yes.
if you speak the truth, you don't get off.
You said it, and you quoted from legislation. If you post this video, believing it to be, whether you know if it's true or not, it is written in legislation. I didn't want to go back specifically to quote it, because I don't want to paraphrase Mr. Chairman. So let me capture it here, please. I think it was under the cyber bullying section, maybe, where it speaks to being true or not.
The-
Right. Sorry,
Yeah, you have it there, if
I'm
not.
trying to find it, but it's right here.
Showing cyberbullying section 20. Because we were talking about section 19, Mr. Stuart, and you move on now to 20. So, like you can see that what I've said, you have no answer to, because you now move on to cyberbullying. So let me hear what you're going to tell me about cyberbullying now.
But I have not moved on. The legislation, all of these are offenses. So one offense for me, at the end of the day, is offense, right? So you got to face the same punishment, maybe a little more money, a little less money in some instances, but it's still an offense. But I want to take the specific reference in the legislation where it says, if you post this thing believing it to be true, without knowledge of if it's true, right. It says here at section 19, part 3, a person who intentionally uses a computer system to disseminate any images or words, not caring whether they are true or false, and causes or is likely to cause or subject a person to ridicule, contempt, or embarrassment is guilty of an offense and is liable on summary conviction to a fine of $70,000 or to imprisonment for a term of 7 years or both. So if I go by your reference, you're saying to me that only this specific section, which is section 19, right? Only that specific section, if I publish something, whether true or not, I can only be charged under the offenses specifically listed under section 19. Is that what you're saying?
But you have come to tell me, sir. What I'm saying is that I see in section 19.5 a defense. I'm not saying you can't be charged. You know, a lot of people are charged and they're found not guilty. But section 19.5 protects you, doesn't it?
So if I speak the truth, right? If I speak the truth in the first place, then I can come back with the truth again as a defense. But why do I have to go through the public ridicule, right? Remember, why do I have to go through the public ridicule for speaking the truth in the first place, that I can be charged, that a police officer can take it upon himself to come to my house, seize my laptop, my computer, my devices. I'm taken to a police station. Bear in mind, I have not spoken yet, as the police engage you. You have to go to court, spend money, hire a lawyer, do all of these things to prove.
Mr. Stuart, we don't live in a perfect world, sir. We don't live in a perfect world. Anyone, we're all men on this committee, and you're a man. You know very well, sir, that tonight, someone can lay a charge against us. Sexual assault, for example. So what are you saying? What are you telling us here?
Well,
it may not be true.
Right.
Police come for you based on that allegation. So what is the difference between that and this, sir? I really don't get you.
But let me give you an example that's close to home, but I will not speak because of subjudicate, and so I won't speak the details. But let's just say a scenario occurred, sexual assault, as you said, and this person happens to carry a public position, right? I saw in real time and real life where information was put on the internet purporting to be information originating from the Barbados Police Service, right? Purporting to be. Now, whether this information was true or not, the facts were put out there, right? This person has to go through the court. Wait, let me say one thing.
As you said, subjudicate.
Right.
But
Right, I'm not speaking, but I'm not speaking.
you're essentially agreeing with me.
No, I am essentially saying, right, that if this person has to go through a public ridicule based off a false allegation, right, false allegation, because it's the police officer who has to lay the charge, so that person has to determine whether or not to proceed after a complaint is laid, I suppose. Nothing like that was said here, right? I suppose. Right? So this person has to go through that scorn and that. If that person is found not guilty, right? If that person is found not guilty, which is the person accused, right? What happens? What happens then? What happens then? Right? So you then back to square one when you lost all your public credibility, right? You lost all your public credibility on a false allegation.
Are there any other members who wish to intervene and ask Mr. Stuart anything? Mr. Stuart, you raised one good point. I mean, you asked who will police this in the police force. And again, that isn't the concern you can appreciate of the legislature. I mean, the legislature passes laws. It is up to the police to decide how they now will monitor or implement the law or police, quote unquote, the law. So that can't be a reason for not passing the law. You could appreciate that. I just came back from Trinidad this morning, and when I asked, yes, their police department has a separate cybercrime unit to deal with, not Trinidad, sorry, Guyana. Guyana has passed the law, Trinidad hasn't. And I was told that Guyana has a separate cybercrime unit to, monitor and enforce the law. But that's not Parliament's role. You concede that. Okay? And police excessiveness, you spoke about. That the police, would have the power if they suspect a crime is about to be committed, to pursue it. But isn't that so with other laws as well? Can't the police, for example, stop a vehicle tonight that they feel, may have persons in it, occupants in it, who they've received information, maybe going to commit a crime, maybe going to be involved in a drug bust or not? What is so different with the legislative provisions of this bill as drafted to existing law? Yeah.
Right. Your first comment about policing, my grave concern there, you said it's not reason not to pass the legislation, but my grave concern stems from the fact that our political system, our Westminster system, and in particularly the Mutual Assistance Act of 1980, names the Attorney General as the central authority as it relates to mutual assistance in criminal matters, right? By nature, the Attorney General, in origin, the Attorney General is a person who first and foremost is a member of a political party Second thing, second, a member of parliament, and then you are elevated to that job based or at the courtesy of the prime minister, right? So the attorney general being the central authority and biased in that he is a politician, a member of a political party, and biased also from the fact that the prime minister, who that person serves at their behest, follows something called collective responsibility, right? And upon instruction, the police force can become politicized to the point that it can be used to enact witch hunts on people based off the directives coming from the central authority, right? Second thing, second, your next comment, the last comment you said, if you remind me quickly.
Police having the authority to intervene where they suspect a crime
Right.
may be committed.
Well,
Yeah, about to be committed.
yes, but the example you give is in that of a physical nature, flesh, blood. We talking now cyber. Hence the reason it's called the Cybercrime Bill, and hence the reason it's called the Mutual Assistance for Criminal Offenses as relates to the computer, right? So how would you know that I am sitting here on my device planning to commit a crime unless you were actively spying or monitoring on my device? So if anybody, any committee member could say, how would you know that a crime is about to be committed on a laptop or a tablet? You have to be seeing it. And if you're not doing the spying yourself, you have to be engaging the service provider like Lime or Digicel or AT&T or some, and there are clauses in this bill which speaks to that. And my fear here is that the telecommunications companies can be intimidated and bullied into sharing the private information of the public based off the structure of our current political system.